programs that we have. As you know, on filing, the matter gets deferred into the mortgage foreclosure program. An answer is not filed to the complaint. And we monitor the progress of the program through this procedure. What we have found with the study is that we're getting a little bit long in the tooth on some of the cases, and some of the time to disposition critical elements are getting a little bit longer. So we're looking at it. We're trying to see how we can tighten it up a little bit. The number of conciliation conferences. The other day, talking about using our resources, I called Steve Wilco about a month ago, and I said, Steve, I need the time to disposition, I need the number of conciliation conferences, I need the median number, I need the low number, I need the high number. And within 2 weeks, we had a report. So that's the kind of analysis that we can do on the programs. And what it suggests to me is that we have to do more with our current resources. And as you know, in a large urban environment, frequently you're challenged to do more with limited circumstances. And in budgetary times, which are tightening, we are in that position now. And that's where you come in, quite honestly, because you provide that resource that is basically of no cost to us. And you provide the services to the parties who are entitled to the services that help us actually move these cases through our system. Yesterday I was sitting in on conferences for the conservancy cases. I've assumed the responsibility for all of the motions to appoint a conservator. Now, if you're not aware of it, we have this act by our legislature, which is Act 135, which in essence allows the court to appoint a conservator, and that conservator will be responsible for rehabbing the properties in Philadelphia. And I conferenced a bunch of cases yesterday, and I'm getting my feet wet in this area. And my feeling is that in time it may start to take on more of an impact on our civil resources. Once this overhang in our foreclosure program gets liquidated and these properties are sitting there, query whether people are going to have the resources to maintain the property, or if in the case where they're not able to maintain the property, then it becomes dilapidated. It becomes an eyesore in the neighborhood. It becomes a threat to the safety of children in the neighborhood and all those other factors. So, and I'm not sure whether any of you play a role in that Conservancy Act. Does anybody represent anybody under a conservancy petition now? No. You may be. So if you hear of it, you'll know what I was talking about. With respect to the movement of the other programs, I am confident that we are still 98% compliant with the ABA standards, 97, 98. That means that we basically move these cases through the system in a manner which is consistent with what the ABA set years ago as a standard for moving a case. Sometimes I wonder if we're a victim of our own success, because we have recently become a magnet for cases from around the country. And given our liberal venue rules, we seem to be winding up with a whole bunch of cases on the mass tort side and on the asbestos side, where people don't live in Philadelphia or Pennsylvania. And Judge Herron became the administrative judge, and he and Judge Moss have taken on this mass tort program. And there have been some modifications to it so that we believe we can more fairly use our resources for the citizens of Philadelphia and also the citizens of Pennsylvania who are actually paying for this whole thing. But that's a work in progress, and if you've monitored any of the newspapers lately or the legal, you've seen the good work that both Judge Herron and Judge Morse are doing in that area. Your input into this program is critical to our success here. And on a professional basis, it helps us make sure that the cases are moved through the system with the proper representation for people who don't otherwise have the resources to have that representation. But on a personal side, and I speak of this on a personal side because I've taken my wife to home visits and home studies, and I know that her impact upon this family was critical because it helped two children who otherwise might be lost in the system find their way through the system. And it's important for you because many of you are dealing with issues where there's you're dealing with bureaucratic issues, and you're dealing with situations where you're detached from the actual parties who are involved. But in a case where you take on a representation of an individual, you actually get to touch that person, and you get to touch their lives in a meaningful way. And I always think about waking up in the morning and I say to myself, I really would like to make a difference today. And doing what you do enables you to make a difference in somebody's life. So I applaud you for your efforts, and I thank you for inviting me to have these brief moments to speak with you and just say, keep up the good work. Thank you. I don't want to take it with me. Thanks.
Thank you, Judge. It's always helpful when we're doing any kind of program to get the perspective of the bench, because there's always the perspective that the bar has when we're handling these cases, but it's always good to get a little insight from the other side of that room to see how the judge looks at some of these cases. And it's also really encouraging to know that the bench in Philadelphia County is very supportive of organizations like the Support Center and Philadelphia VIP and the other legal service agencies, because they know without the involvement of you as volunteers taking these cases, that's more pro se litigants that are appearing in front of the judges. Just another statistic, over 80% of the cases in family court in Philadelphia have no attorneys at all. And there are thousands upon thousands of cases that are filed every year in family court. I'm confusing whether the number was 8,000 custody filings or 18,000 custody filings in 1 year. And that doesn't count support, divorce, abuse, or anything else, though just in custody. And I know the other aspects of this, of the civil side have similar numbers. So
yes, I can give you, actually I have a number here.
Ooh.
Last year, we had 2,171 newly created pro se litigants. And prior to that, there was about 5,000 in the system. So we probably have around 7,000 pro se litigants that's actually electronically filing their own.
And with your help, that's less pro se litigants filing electronically in Philadelphia County.
Thank you.
So, Maisha, was there something else you want to talk about with regard to the filings in mortgage foreclosure cases?
How things get started. There's just one word that I would note to folks who do come and assist us with foreclosures, in addition to saying thank you so much. When you do get cases started, or when you're wrapping up your negotiations, say your case is coming to an impasse, you haven't been able to reach some sort of agreement, please be sure that you get a certain amount of time to actually file a response, because that is not necessarily built in. And definitely, if you can't litigate the case personally and VIP needs to find another advocate to litigate the case. We're going to need time to find someone, familiarize them with that case, and get the answer drafted and filed and the verification signed and the works. So that's just something to keep in mind when you're working from a defensive posture, particularly if you're delaying the time when you respond to the answer. Always make sure that you have sufficient time to file.
Now, on the family court side, everything is filed not electronically, as we're saying, it's filed in person or by mail. It's sent to, most cases are sent to 1133 Chestnut Street, the clerk of the family court. In your materials is a handy 2-page chart called Where to File. So for the different types of cases, based on the subject matter, what the filing location is, and whether or not things are filed electronically, this may be one of the better resources from these materials, because it gives you a quick place to, if you're handling an adoption case one day, and 3 weeks later you've got a private client who's got a landlord-tenant case, well, it's not going to be filed in the same place. You've got now a chart to let you know what gets filed where. So definitely feel free to use that. We've also provided, when possible, phone numbers. So if you have a question about how many copies get filed, again, this is not the electronic filing, but for the paper filing, definitely double check how many copies. When you're filing something, the question is not only how many copies get filed, always ask how many copies you get back, because you're going to have to take care of service. And Regina talked about service as well. There are separate service rules for family court as opposed to other civil matters. Philadelphia VIP can offer some assistance with regard to service, but please look over the rules. Many things can be served by mail and will not require someone to do personal service. If it gets to the issue of personal service, that can become expensive. So please feel free to contact us. We can brainstorm to come up with different options. For example, in family court matters, if you can't serve someone by mail and you have to personally serve someone, it can be done by any adult, as long as it's not the party. So I've discussed with volunteers, does your client have a friend who knows the defendant who can just hand the document to the defendant? It's that simple. Then you just have an affidavit of service prepared. You don't have to worry about incurring the cost of a process server. Sometimes you do have to take that step, and then we can discuss on how that fee is going to be paid, because not every process server will give VIP a reduced cost. So we talked about how things get started. What about what the defendant files?
Can I break in for 1 second? Sure. on the idea of getting an extension of time? Say you're not going to handle the matter yourself. In civil litigation, and I'm usually a plaintiff, okay? But in a mortgage foreclosure case, I have a lot of complaints, but that's it. In a mortgage foreclosure case, you would be the defendant. And there's this little rift that goes on when you call the plaintiff's lawyer and say, I'd like an extension of time. And then sometimes the plaintiff's lawyer here, a bank or somebody else, would say, well, I'll give you an extension to answer, but not to file preliminary objections. Anybody ever hear that game? Yeah. So if you're on the defense side, you want to try to avoid that, especially if you're handing the case off, because you don't want to tie the hands of your successor in the case. Now, in reality, I don't know that judges pay attention to that. I think preliminary objections are often filed anyway past the time frame, and they seem to be accepted by the court. But sometimes judges will enforce that. So you want to try to keep your options as open as you can if you're going for an extension. And then you can sort of, in a pro bono case, don't hesitate to say, come on, I'm pro bono counsel here. Don't be a hard nose about this. Let me just try and get my feet on the ground here with the file, et cetera, et cetera. Play the sympathy card and see if maybe that will give you a little more leeway. But you want to leave that playing field open if you can.
So Regina, what other types of filings are there? Because Jerry had mentioned preliminary objections. Mm-hmm. What else would a defendant be filing?
Well, once you've filed the complaint, you've heard about preliminary objections. That's governed by the Pennsylvania Rules of Civil Procedure 1028. And if you look there, it gives you a number of reasons why you could object to the complaint. It could be improper venue. It could be that it's just not sufficiently pled. But if you're going to, if you're the defendant in the case and you wish to file the objections, you technically are supposed to do it within 20 days. You need to have the notice to plead. and you need to file your motion package properly with the courts. Alternatively, however, if you've opted, you know what, I'm not going to file objections here, the complaint looks okay, then you can file what's called an answer. And answers are governed by Pennsylvania Rule Civil Procedure 1029. That talks about what denials you may place in your answer and what types of averments require specific denials versus legal denials. But in filing the answer, you can also file what's called a new matter. And that would be if you're going to assert any kind of affirmative defense. And if you're going to do that, you again have to have this notice to plead, because now it's sort of ping pong. Now it goes back to the plaintiff, and they will have to respond to that new matter. You know, and there's an argument to be said, if you don't raise new matter, you don't raise affirmative defenses, and you can't raise it down the road, you know, you'll go back and forth on that issue. But, you know, it's in your interest, if you think there's a possibility that you may want to raise an affirmative defense down the road, you might as well plead it at that stage and protect yourself and protect your client. So it's answer with new matter. Now, back to the preliminary objections, if you did choose to file preliminary objections, the plaintiff can file what's called an amended complaint within 20 days of receiving those objections. They can either file a response to the preliminary objections and try and fight them in court, or they can file an amended complaint, at which point then you can review that. If they've cured any of the defects that you felt were valid, then you would do your answer. But if you still feel like the complaint is not up to snuff and, you know, not adequate, you can again file preliminary objections. You've got to still keep it within your 20-day time period unless you've got some kind of extension going on. So those are generally the responses that would take place at that stage once the complaint's been filed, and now it's POs or answers with new matter. I don't know if it's...
Do you run into situations like that with mortgage foreclosure cases?
Absolutely. It's exactly the same.
And then there's family court. One of the things, one basic rule of civil procedure is all the allegations contained in a complaint are specifically considered admitted unless they're denied, except in family court matters. Actually, by rule, all the allegations contained in a divorce complaint are considered to be denied. So the other side does not have to file an answer. In most support or custody cases, answers are not necessary because the court's going to consider them as being denied, except for the basic information about, you know, someone being a parent and that the children exist and their names and ages. So you don't see too many responsive pleadings in family court. The times you do are when the other side wants to raise additional issues. So you'll see an answer and counterclaim, occasionally an answer in a new matter. Rarely preliminary objections, but those issues do come up as well. But you just have to keep in mind that while in mortgage foreclosure cases, in products liability cases, slip and fall cases, almost any other type of civil case, you would need to file an answer if you're going to contest the allegations of the complaint, except in family court. So that's why you don't see too many responsive pleadings. However, in family court, it becomes very important for that reason to enter your appearance on behalf of the defendant if you're representing the defendant. Otherwise, you will have no way of knowing what's going on in the case because the court will not know you're involved because you don't necessarily have to file an answer. Is that kind of clear? There is a filing fee to enter your appearance on behalf of a defendant in family court. So you'll be filing your IFP paperwork, so that fee gets waived to make sure you've got it all, always have your bases covered. If there's a filing fee for something in family court and you don't include the filing fee, they will just reject it right then and there. They'll say, where's the filing fee? Here, take this back. And this is done by people. It's not done electronically. So you'll probably find out the second you take it to the counter, where's the fee? So just keep that in mind.
It looks like we have a question.
Oh, I'm sorry.
Michael, do we send the client down to fill out the IFP information and file a petition, or do we file a petition for them? In Montgomery County, we just send them down?
Well, in Philadelphia County, as the attorney, you fill out a single precipice, which is included in the materials. So you just basically say the client meets the requirements, meets the income requirements, that you are not charging the attorney, as the attorney, you're not charging the client any legal fees, and in most instances, the court will just accept that precipice. It's a lot simpler process. It doesn't get into the client's income and assets because that determination has been made already by the legal service agency. They determine that the client qualifies for free legal representation. So for the most part, in the first judicial district, they're not going to second guess the legal service agencies, and they'll accept that representation. So it's just a one-page recipe, which is included in the materials. And when I, for example, send out the information to a volunteer for all the information for the case, I will include the IFP paperwork. There's also the IFP paperwork, which is available from the court's website. That is if the client is going to be filing for IFP status pro se themselves, and it's a fill-in form that they can fill in and then print out and then file with the court. Thank you.
Let me just follow up, Mike. You did mention counterclaims, and I forgot to reference that when I was speaking. In the civil arena, when the defendant is going to answer the complaint and perhaps add new matter, they also have an opportunity, if there are other defendants also named, to file a counterclaim pursuant to rule, I think it's 1031, and also a cross-claim, which would be a claim back against the plaintiff under 1031.1. So those are other concepts to keep in mind when you're preparing your answer and deciding what avenues to take in response to the complaint.
This doesn't happen too often, but how are jury trials demanded in Philadelphia?
Generally, they're demanded
On the complaint?
on the complaint. We often will do demand for a jury trial on the actual caption of the complaint. There may be some instances where strategically we do not demand a jury trial, but often the defense then, in responding to with their answer or preliminary objections or whatever it may be, will include it on their caption. So that's generally how it's done in the civil arena.
Anything different with mortgage foreclosure cases?
Only that in mortgage foreclosure cases, we're the defendants and we include it on our captions because almost invariably plaintiff will try for a bench trial and they will push very hard for a bench trial.
Mm-hmm. It is technically possible to have a jury in a family court case. It's very rare, and there are very few circumstances where it can actually happen. Off the top of my head, I believe you can actually have a jury trial in a paternity matter, but usually not for property division in a divorce, not for custody, not for protection from abuse. So for the vast majority of cases in family court, there are no juries. So don't even worry about having to pick a jury in those cases. Let's shift gears a little bit and let's assume the case has already been started, either by the other side or by your client, and you're now jumping into the middle of a case. What happens with regard to the discovery process in Philadelphia?
All right, so once in the civil arena, once you've instituted a suit, you've got your complaint, you guys have gotten through the sort of hurdles of preliminary objections and they've filed an answer, you're going to start what we've called the discovery process, which is going to include written discovery, which are interrogatories. They are governed by the rule 4003.1 sort of through 4005. And I had asked Charles earlier that question about the Philadelphia Civil Practice Manual because contained within that manual are a number of forms that are very useful in civil matters, particularly as it relates to discovery. They have personal injury written discovery forms, which is, I think, Form 6-1. They have product liability action interrogatories. They have medical malpractice interrogatories, motor vehicle and premises liability interrogatories. Now, having said that, they are forms, they're fairly general, but it at least gets the ball rolling. You're going to file these on the opposing party. They have 30 days within which to answer and or file any objections that they wish to place on the record as to your questions. Depending on the nature of your particular case, you may add additional questions that you want answered. You may file a second set of interrogatories. You can file set 1, set 2, set 3. As the case is evolving and progressing, things may come up and you say, oh, I really want to know the answer to that. Let me file. You know, I've had instances where I filed one written interrogatory because I want a specific answer and I want to have that document ready so that down the road, if we get to trial, it's an easy exhibit, it's easy to pull up. So that's one method of discovery. The second method are requests for production of documents. And that's your opportunity to gather as much information and as many documents as you need to continue to establish your case. So again, you would file that on the defendants in the case, and it would be a list of questions asking for specific documents. I think the rules do require that, you know, when you actually set forth the interrogatory, you leave sufficient space for the answer. Most people generally know, you know, they can go to a second page, they can put it on there, they could answer it separately. You know, I don't think for purposes of the case it's that significant, but the rules do set forth specific requirements in that regard. In any event, the request for production of documents is the opportunity to get a hold of as much information as you can to continue to establish and evaluate your case. You generally can place that on the defendants, but you can also issue subpoenas to parties that are not defendants in the matter if you need to obtain documents from those sources. When subpoenas are issued, you have to give 20 days notice to all parties involved so that if they wish to place an objection, they can do so. In our practice, often the defense issues subpoenas on our clients' medical records. For the most part, we do a lot of medical malpractice and product liability, and the medical records are going to be, a valid discovery mechanism. In some instances, there can be a basis for those records being protected for some reason. If they're mental health records and they may not be pertinent to the case, you want to ensure that you file the proper objection to preclude that subpoena from being issued to that non-party, because if the subpoena gets issued, that party is going to comply with the subpoena because they're getting a subpoena and they're like, oh, I better do this, or I'm going to, somebody's going to come knocking on my door. So you need to be particularly cognizant of those kind of issues as it relates to your case. The third sort of avenue of discovery is depositions. Strategically, it depends on your case, whether you want to jump right in and start taking deps, or you want to gather written discovery and get documents and get as much information as you can so that you are ready to go when you take the deposition. That really depends on the case, depends on the facts of your case. Once you get to the step where you're going to take deposition, you need to file, or not file, but you need to send a notice of deposition to the other party. You need to identify who you're deposing. You need to have a court reporter referenced on the notice, and it has to be a certified court reporter who is able to give the oath and take the deposition and do the transcription. You need to, of course, if there's multiple defendants, everyone needs to be aware of the notice of deposition. And then you would embark on the deposition and get what information you can. Depending on what information you get, you may take witnesses. You may wish to depose people that are not parties in the case. In that instance, it depends on the nature of the witness. If it's someone you are permitted to contact, you can do that in an effort to set up the deposition. If it's someone that perhaps is not going to be a friendly witness, you may need to issue a subpoena, and then you, of course, have to include all parties in that process. In some instances in the civil case, your client may have a treating physician that may be critical to the case. Be aware that the defense is not permitted to contact your client's treating physician without permission of your client and, of course, you as the counsel. That is not permissible. You may contact the treating physician. You may take his deposition if you wish. You may have to issue a subpoena to do that depending on the circumstances. But the defense is not permitted to contact or speak with the treating doctor of your client without authorization from your client, which generally you probably would not want to give.
What information can you share, Regina, about discovery deadlines? Not ones set by the rules, but ones set by the court.
Yeah. In Philadelphia County, we have a case management system, which Charles probably can speak to.
I'm sorry.
Once you file your case, whether by writ or complaint, I guess it's about 90 days later, they are going to issue what's called a case management conference. That's going to be a conference that's held on the 6th floor, and I never...
Let me just cut in.
Sure.
All of our civil programs are event-driven. The first we create these significant events to move the cases through the system. The first significant event, especially in mixed jury cases, in all cases now, including non-jury, is a civil case management conference where you meet with a lawyer, one of our staff members, and we discuss the case, get the issues on the board, and then at the end of that conference, the goal is to issue a case management order that's going to govern the movement of that case through the system. One of the most important deadlines in that case management order is the discovery deadline. So if you file a major jury case and it's determined that this case is going to be placed on an expedited track, we're going to move that case to disposition hopefully within 13 months from the date of filing. The case was filed in January of 2012. By January